anybody have questions?
Going once, going twice. Okay. Let's take you want to take a 5 or 10 minute break before we get this last block of ethics. 5, who says 5? Who says 10? Okay, the 5s have it, all right. 5 minute break and we'll start with ethics. Thank y'all for hanging in there.
So Jim, Robert, how do you think, how does one manage the care and feeding of a client in one of these cases?
Well, I touched on that, I think briefly earlier, but when I spoke of your client being locked up, having plenty of time, and being highly anxious, and over the years, I found that there are two basic ways to approach that client successfully. All of them, the problem with a client is that he tends to inundate his lawyers with issues. Because he's sitting there and he's talking to jailhouse lawyers. He's obsessing about his case. All of that's understandable. Jailhouse lawyers are essentially liberated from actually having to know the law. And unlike most of us who are often compelled to deliver bad news, they are not necessarily. As a matter of fact, they don't get cigarettes and favors if they deliver bad news. They get them if they deliver good news. And so you get some bizarre suggestions or insistences upon issues to be raised. I think that the way to deal with those is to treat at least the most prominent ones seriously, or some of them seriously. And I know it's time consuming, but I've traditionally tried to do that. I've taken one of the issues and I've explained in 3-page letters replete with citations to which the relevant cases are attached. To the letter they're attached, explaining why that issue just simply won't fly, why it's ridiculous, and why it's wrong. Excuse me. And you've got a credibility problem again because you're in competition with a jailhouse lawyer quite often, and they can disbelieve you. But I've always figured that they can't really disbelieve the cases if you send them the important cases and say, this is what I've said about this is what the state Supreme Court has said about this, and what the U.S. Supreme Court has said about this, and what the 11th Circuit has said about this, and what the Court of Appeals has said about this. And if you do that to just a few of the issues, they tend to be impressed by what you know and how seriously you've taken the claims, and they'll be more receptive to some sort of dealing with some of the others in a summary fashion. And I will usually culminate a letter like that saying, look, I've dealt with these issues, but nobody's paying me to give you a legal education, and I can't do it. And I've got limited resources to devote to your case, and I don't really think that you want me to spend them trying to tutor you on the law. You go to your physician and ask him to explain these things, and the law is no different, or it's not much different in that regard. And they once they observe you taking their claims seriously and treating them seriously, then they're obviously far more receptive to something like that. And the fact is that if you're talking about having written them a 3-page letter, they know that you've already devoted some of those limited resources that you referred to nothing more than popping a ridiculous balloon that somebody's going forward. And I think they tend to get the point of that perhaps they are better served, their interests are better served by letting you do your job rather than dealing with basically ridiculous issues that they can conjure up, or that come out from behind prison walls. And another thing that I found to be pretty effective also is to be candid with the client with relation to other things. For example, time is the lawyer's friend in these proceedings. You need time to read the transcript, you need time to digest the record, you need time to investigate, you need time to research, and you need time to write. Whereas the client suffers time in quite a different manner. And this is something that you can fruitfully explain to them, that they're in a great rush to have that motion for new trial, for example, heard, whereas excuse me, the point you want to convey is that you don't want it heard before I want it heard, or before you do not want it heard before I can be prepared for it. That is not in your interest. And a lot of these things are eminently reasonable, and I think eventually, I think most clients understand it. Again, what you're at war with is their anxiety, and there's nothing in the world you can do about that. Their obsessiveness with respect to the conviction, can't do anything about that. If you were in their shoes, you'd be obsessed with your conviction too. And then, of course, there's that competition with jailhouse lawyers who are quite free to raise their hopes and expectations, and can make them more resistant to. Can't do much about that either, except show them the law.
Usually, I try to keep the defendants that I represent in appeals apprised generally of what's going on. And I do that through the milestones in the case. It's now the Court of Appeals. Here's generally how things go. I had a guy who had a Supreme Court case in 2008. He was obviously, he wanted to know when the prison people were going to transport him to the Supreme Court so we could present argument together. And I had to go through a long explanation about that's not how it's done at this level. But every time you get to a milestone, you're submitting your brief, or I went up for oral argument, here's what I think, and now we're just waiting. That, in my experience, that tends to keep folks satisfied. Now, you will get some who aren't satisfied no matter what you do. And they'll send you letters and say, I want you to do that. One guy told me that the judge was taking too much time considering his motion for the trial, and therefore I was to dismiss it and file a notice of appeal. And I wrote back and said, fine, and then all the issues we've got are weighed. And he had a venue argument, which eventually overturned his conviction. But I had to write him back and say, that's a bad idea, and here's why. And, kind of laid it out. And he wrote me back and said, okay, that makes sense. And he sat down and backed down. So one thing I would suggest not doing is, you're going to get letters from these folks who say, what's the status of my case? Or I found this case and it says A, B, and C. I know some lawyers who take those letters, throw them in the files, and don't respond to them at all. I think that's a mistake. It's like you're stoking a time bomb. Respond, say, thanks for sending me that, but this has nothing to do with your case. Do it politely and professionally, and I think that you'll be able to maintain a decent relationship with that person.
One thing that I forgot to mention, and other speakers have mentioned Jones versus Barnes, the case that makes it clear that the selection and the treatment of appellate issues is the prerogative of counsel. I must copy that case once a week, but usually when I'm in the course of the correspondence that I just described, I will send these people a copy of Jones versus Barnes, again, because Jones goes out of its way to explain why you winnow issues down, and some things that is worth the client knowing from reading the Supreme Court opinion rather than taking your word for it. And the opinion says it much better than most of us can anyway. And that, once altogether, that kind of makes it easier for you to make the calls that you have to make. For a lawyer to make the calls he has to make in those cases. And Most clients, the way they approach it is, they obviously, they don't know the law. They've got no legal training. And if they have no detachment by which they could apply that training. And because of this, they don't know the difference between a good issue and a bad issue. They wouldn't know ex post facto if it was big, biting in the knee, So their general, the general philosophy is, what, just 40 issues, why not 50? And you get as many as you can, you throw them against the wall, and they think that they have this idea of what the appellate court will do, that, somebody is gonna be the mass crusader on that court, and they're gonna look at some issue, and they're gonna order an investigation, and they're gonna do all this kind of stuff. They have just no idea. Whereas, in point of fact, the quickest way to lose a case is to throw all that stuff against the wall. And because a lawyer is cursed with training and the ability to discriminate between bad issues and good issues, he or she is supposed to exercise that training and discretion and eliminate the ones that most untutored clients would want, would want thrown against the wall. And it's just one of the things you have to deal with. But as I said, if you can demonstrate that you know what you're talking about, demonstrate your sensitivity to the position they're in, then all of those messages be conveyed a little bit better.
Let's shift gears for a moment and think about the ethical underpinnings about why we're here. It would be, we've got limited resources available for the defense of these clients. It'd be more economical if the public defenders could just represent all the co-defendants in cases. We wouldn't need conflict defenders, and maybe we wouldn't need to be imposing on all of you. Why can't we do that?
I guess we can't, as a state legislature won't let us.
Well, one of the reasons too is that, and I think most jurisdictions, appeals run on the record of the trial. There's relatively little opportunity to expand that record. And I think that when you've got that kind of thing, you have co-defendants, probably doesn't make a difference whether they were tried separately or tried together. But I think that a lawyer confined to the paper record is probably relatively free from any real conflict. The problem we have in Georgia is that we have this opportunity, and indeed in some matters the obligation, to expand the record through that motion for any trial. And that tends to put appellate counsel in pretty much the same dangerous position as trial counsel, where the danger is that the obligation to keep one client's secrets will be in conflict with the obligation of the other client to use those secrets in his interest. That to me is the real source of how the traditional conflict kind of endures into the appellate process. Again, my view of it would be entirely different if appeals were limited to the sort of the paper record of the conviction. I think there would be far fewer opportunities. Well, you wouldn't have the problem of secrets being divulged, because if something's not on the record, it didn't happen, you can't use it anyway. And you could argue each case sort of on its own legs. And the fact that the law is the same, is incidental, I suppose. It shouldn't affect the advocacy, I would imagine.
Switch to another ethical topic. To what extent, if any, should an appeal be structured with the idea that the appeal is not the end of the road? There's a right to pursue habeas in the state courts, and then to appeal in the federal courts. As an appellate, as a lawyer on direct appeal, are you doing anything to set up or preserve habeas rights?
I don't, personally, I think if you're the appellate lawyer, your job is to deal with what you've got, present the issues. I don't know that it's necessarily wise to be thinking ahead. I mean, it may be wise to say, I raised the issue and preserve them. But I don't view, at least from my standpoint, that the appellate advocate's role is to set up federal or state habeas. I'd like to hear what Jim has to say, because he's done more habeas than I have.
Well, it's different. I think what Robert has expressed is probably the governing sense in ordinary cases. But death penalty cases kind of turn the world on its head. For example, everything that we've spoken of, or one of the things we've emphasized today, that idea of winnowing issues down and discriminating among them, is absolutely 180 degrees from the rule that prevails in death penalty practice. And the reasons are actually pretty clear. In an ordinary burglary case, contemplating the end of the day is you can do that. In a death penalty case, contemplating the end of the day can be terrifying, because that could result in your client being executed. And so, whereas in an ordinary appeal, you want your best issues going forward, you want to conclude the case somehow, and you hope to win it. In a death penalty case, a part of the game is a lot of those cases cannot be won, or certainly not easily won. And a great deal of the emphasis is retarding the system, is making the record more confusing, the arguments more numerous, the case more complicated. and always in the appellate phase of a death penalty case, those people do have their eyes on the habeas aspect of it. Because unlike other ordinary, Joe Blow who did a burglary, these people are going to be represented pretty much throughout that process. And the idea of saving something for the habeas lawyers is very, very prominent in capital appeals. As a matter of fact, the bane of our existence, that Garland case and this easy substitution of counsel, in death penalty cases, they try very hard, and trial lawyers understand this, to keep trial lawyers on the case, even if they're not going to do anything but sign the brief. And the reason they do that is to save Sixth Amendment claims for habeas corpus, where frankly I think they belong. But there's a case I think going on now over in Douglasville